Hello and welcome to Courts Today by LiveLaw. Let us get to today's top legal updates. In the Prayagraj police assault matter, the Allahabad High Court Bar Association has filed affidavit in the High Court detailing atrocities against lawyers. The Supreme Court is set to hear the Places of Worship Act matter in the month of April, saying that even person accused of heinous crimes is entitled to basic protection of law. The Supreme Court has set aside a death penalty for lack of fair trial. In the Uttarakhand Uniform Civil Court challenge, the High Court has questioned privacy concern in registering the live-in relationships. The top court has held that if accused is to get final verdict after 6 to 7 years in jail as under trial, it means that right to speedy trial has been violated. And the Apex Court has issued notice to Uttar Pradesh authorities in contempt petition over part demolition of a mosque and stayed further demolition. I am your host Urvashi Chauhan with your daily roundup of legal updates from across the country. For detailed reading, you can always visit our website at www.livelaw.in. Please make sure to watch this video till the end and do not forget to like, share and subscribe to our channel. The Allahabad High Court Bar Association has submitted a supplementary affidavit and a pen drive to the Allahabad High Court in response to a criminal writ PIL plea. The plea demands filing of an FIR against police officers accused of assaulting lawyers in Prayagraj on 4th February. Pursuant to the High Court's previous orders, the concerned divisional commissioner, Mela Adhikari, the police commissioner, the district magistrate and the deputy commissioner of police have also filed their respective affidavits. The affidavits were taken on record by a bench of Justice Rajiv Gupta and Justice Mohammad Azhar Hussain Idrisi. If you recall, the High Court Bar Association had written a letter to the Chief Justice highlighting that police had prevented the lawyers from reaching the High Court and blocked the road for some VIP movement. It was stated that the police had assaulted the lawyers when they asked for access to the road. The Chief Justice had directed that the letter be converted into a criminal public interest litigation, which is now being heard by the division bench. This matter is coming up for hearing tomorrow. Stay tuned. In the next update, the Supreme Court bench of CJI Sanjeev Khanna and Justice Sanjay Kumar today deferred the hearing of the pleas concerning the Places of Worship Act 1991 to the month of April. You are aware that the bench is seized of one set of petitions challenging the constitutionality of the Places of Worship Act 1991 and another set seeking strict enforcement of the act. In wake of multiple suits being filed in courts challenging nature of certain religious places, seeking their surveys and demolitions, some of which have unfortunately also led to violence, various petitions have been filed before the top court challenging the validity of Places of Worship Act. It is because this statute aims to preserve the status quo of religious structures as they stood on 15th August 1947 and prohibits legal proceedings seeking their conversion. Petitions and intervening applications have been filed from both sides, one challenging the act and the other advocating for its strict implementation. This matter was earlier heard by a 3-judge bench comprising CJI Sanjeev Khanna, Justice Sanjay Kumar and Justice KV Vishwanathan. Since today the Chief's Court was sitting in a 2-judge combination, the matter was adjourned. Taking note of the multiple intervention applications being filed in the main matter and also similar writ petitions, the bench directed that any pending writ petitions in which no notice has been issued would stand as dismissed. However, liberty was granted to such writ petitioners to file applications raising additional grounds in the ongoing matter. The bench was today also informed that no counter affidavit has been yet filed by the union in the main matter. Moving ahead, the Apex Court has set aside the death sentence of a man accused of killing his wife and 12-year-old daughter after noting that he was denied a fair trial guaranteed under Article 21 of the Constitution. A bench comprising Justices Vikram Nath, Sanjay Karol and Sandeep Mehta allowed the man's appeal, overturning the Allahabad High Court's decision that had convicted him of murder and also imposed the death penalty. The Supreme Court noted several issues in the trial that led to the denial of a fair trial. The defense counsel was absent when key prosecution witnesses were examined, and cross-examination was not allowed properly. Additionally, the defense statements were poorly recorded, with vague questions asked to the accused, missing important incriminating details which could have caused prejudice. The court also noted that the appellant's counsel were changed frequently and insufficient time for preparation had led to ineffective representation. It emphasized that simply appointing legal aid counsel is not enough. The representation must be effective and meaningful. The court ruled that the trial court's failure to ensure competent legal representation violated the appellant's fundamental rights here. The court also referred to international law obligations, particularly the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. Both of these guarantee fair trial and representation to the accused, even though the accused might have committed gravest and most heinous crimes. The court has also said that in capital punishment cases, the highest standards of procedural fairness must be adhered to. Accordingly, the court set aside the conviction and death sentence imposed by the trial court and confirmed by the High Court. The case has been remanded back to the trial court for a fresh trial starting from the stage of framing of charges. And now an update on Uttarakhand's Uniform Civil Code. While hearing another writ petition filed by a 23-year-old man challenging specific provisions of Uttarakhand's UCC, particularly the mandatory registration of live-in relationships, the Uttarakhand High Court today orally remarked that the state government is not prohibiting live-in relationships but is only providing for their registration, which does not equate to a declaration of such relationships per se. Appearing before a division bench comprising Chief Justice G. Narendra and Justice Alok Mahra, the petitioner's counsel Advocate Abhijay Negi argued that by mandatorily provisioning for the registration of such relationships under the Uniform Civil Code, the state is institutionalizing gossip. Referring to the Supreme Court's 2017 K.S. Puttaswamy judgment, he stressed on the right to privacy, arguing that his client's privacy is being invaded as he does not wish to declare or register his live-in relationship with his partner. The bench, however, refuted his argument that UCC does not provide for any declaration and that it is just asking people to register for such a relationship. The Chief Justice questioned what secrecy was being referred to, as both individuals were living together openly with neighbors, society, and the world aware of it. The Chief Justice remarked that they were not living in secret but openly within civil society without marriage and asked how privacy had been invaded here. The bench further said that the matter would be tagged with other petitions challenging the UCC, and if any coercive actions were taken against any individual, the concerned person could come to the court for help. Well, this is similar to what the court remarked orally last week while hearing another similar plea. It may be noted here that 2 other petitions are pending before the Uttarakhand High Court challenging the Uniform Civil Code. Moving further, a Supreme Court bench of Justices J.B. Pardiwala and R. Madhavan has granted bail to an accused charged under the UAPA who was arrested by the Chhattisgarh police on the allegations of carrying articles ordinarily used relating to Naxalite activities. The accused has been under custody since 2020 and the prosecution intends to examine 100 witnesses, of which 42 have already been examined. Questioning the need to examine 100 witnesses, of which the majority have deposed similar testimonies, the court noted that no purpose would be served if the 100 witnesses were examined to establish one particular fact. Relying on the case of Malak Khan versus the Emperor from 1946, the court stated that when there are many witnesses, it is not necessary for all of them to be produced. It also highlighted that keeping an accused person in jail for a long time as an undertrial violates their right to a speedy trial under Article 21 of the Constitution. The court further said that long trials cause stress, financial loss, and social stigma. The court pointed out that the acquitted individuals have to rebuild their lives without compensation, often losing jobs, relationships, and facing legal costs. Based on this, the court allowed the appeal here and overturned the High Court's decision to deny bail. And lastly, the Supreme Court today issued notice on a contempt petition against Uttar Pradesh authorities for allegedly violating its November 2024 judgment. The petitioners claim that on 9th February 2025, parts of the Madni Masjid in Kushinagar, UP, were demolished without prior notice or an opportunity for hearing as mandated by the court's November 2024 guidelines. Let me remind you here, the Supreme Court's guidelines from November 2024 order requires prior notice, a hearing, and time to challenge demolish orders. Violations can lead to contempt proceedings with officers liable for restoring the property and paying damages. The petitioners in this case argued that the construction was on private land sanctioned by municipal authorities in the year 1999 and had been inspected by the STM, who confirmed the structure adhered to the sanctioned plan. They claimed that a small part of the construction found to be unauthorized was voluntarily removed by them. Despite this, the authorities went ahead with the demolition, breaching the Supreme Court's directions. Senior advocate Huzaifa Ahmadi, representing the petitioners, emphasized that the demolition was carried out after the SDM's report, which supported the legality of the construction. He argued that the demolition was a clear case of egregious contempt, as no demolition notice has been issued and the property was still under sanction. He also pointed out that the authorities acted after a complaint from the local politician, which set the demolition in motion. The court, after hearing the arguments, issued notice to the authorities asking as to why contempt proceedings should not be initiated. The court has further ordered that no further demolition should take place until further directions. The matter is now pending, with the court scheduled to hear it again in 2 weeks. Stay tuned.